Well, thank you, Francesca, and good afternoon, everyone, and thank you for joining. I hope this is going to be a very informative presentation for you, whether you are new to condemnation. Hopefully, none of you have been condemned, but if you're facing condemnation or you're concerned about maybe this in the future, this will give you some basic guidelines in the next 45 minutes about what to expect, what the process is. It is rather complicated, but I'm going to highlight some of the major points for you today. And again, I'm Patrick Reznik. I'm an attorney here at Braun Gresham. I'm one of the principals, and I grew up in Texas, have been part of farming and ranching in Texas, and have worked throughout the whole state, as well as many of our attorneys here at Braun Gresham. We have a very diverse practice that is focused on landowners around the state, whether it's a condemnation or whether it is dealing with your property taxes related to either ag valuation or wildlife valuation or just taxes in general for properties. We work with folks a lot on transmission line routing. There are some huge projects that are coming up in the state of Texas. There are 765 kilovolt lines, the biggest that's ever been built in the state of Texas. A massive amount of infrastructure that's happening in that area, and as well as general litigation related to easements or land ownership or related even probate, estate planning. We help people manage their properties from a risk standpoint. And we also just help with general real estate issues, especially buying and selling real estate, putting those properties into an LLC or something that helps to manage that risk. And we also have a group that is helpful if you're interested in having a wind farm or solar farm or other infrastructure that is a income generation for your piece of property. So we are very diverse, focused on landowners around the state of Texas. We have about 14 lawyers now. Not everybody is on this new picture, but you can see this is me along with Steve Anderson. We're the gray-haired guys. Steve is in Alpine, but we have a wonderful group of attorneys who are very experienced in all sorts of practices that I just described to you. So again, thank you. As we get into the condemnation practice, we have primarily four people. I know you see three, but four people. Harley Barton and I are the attorneys who handle the condemnation work only for landowners. We don't represent condemning authorities or pipeline companies or transmission line companies, cities or counties. We only represent landowners in condemnation proceedings. Audrey is our paralegal, and I also have a executive assistant, April, which we'll put on the slide the next time you join us in this presentation. Let's start about what is condemnation. And people hear a lot of different things about eminent domain or condemnation. Is there a difference between the two? Yes. They're often used interchangeably, but eminent domain is the ability or the lawful authority of a entity or the state or pipeline company or transmission line company to use the powers to condemn people's property. And it is granted by the U.S. Constitution, the state constitution, and various provisions in the various codes, including the property code, the water code, and some other codes in the state of Texas. The focus has to be, though, it is a taking for public use. And when I say taking, I mean taking. This is not a purchase, it's not a buy-sell agreement. Condemning authorities are using this more and more and more and say, hey, we want to buy your property, but we really do have the authority to condemn if you don't want to sell us the property for an easement or for a fee property ownership. That is really problematic for me because it is not a buy sell, and we'll talk more about this later, but it is a taking of your land for a purpose of a third party. And it does have to be for public use. Why is this a big issue right now? Well, there's huge amount of growth and infrastructure in the state of Texas. And if a pipeline comes through your property, the beautiful piece of property that we see right here takes out a bunch of trees. Is it going to devalue your property if you now have a 42-inch gas line on your property? The answer, even just basic common sense, is yes. So you're going to lose value. But how do you understand what is adequate compensation or just compensation? And I'm going to use those terms interchangeably a lot today during this next 45 minutes. And I really want you just to have a walk away from understanding the basics of this process. And it can be a very intimidating process for landowners. I'm going to review the resources that you have available that we can provide you if you consult with us. But again, I want to emphasize this is not a sale, it is a taking. And I'm going to use that word taking a lot today. So, condemnation procedure, what is it? Well, it is a process by which condemning authorities, whether it's a pipeline company, a transmission line company, whether it's TxDOT for a road project, whether the pipeline is for oil, gas, wastewater, water, other chemicals that could be used. That's just part of the whole process. Again, it's for public use that they have to be able to establish. So private property can be taken by a governmental entity or a private entity. Kinder Morgan, for example, is a big pipeline company in the state of Texas. They're building a new pipeline right now for gas, and they name it a particular name, and they start sending information to landowners to build a new gas pipeline from the Permian Basin to the Houston area for processing. Your property can be taken, but it has to be for adequate compensation, or we call just compensation. What does that mean? We're going to talk a whole lot more about that. But if you are being condemned, you will get something from the state of Texas. It's called the Landowner Bill of Rights. And the Landowner Bill of Rights comes from the AG's office or the Attorney General office of the state of Texas, and it will provide you a brief but fairly complete summary of what your rights are. And the AG's office is, of course, the office that also represents TxDOT in condemnation proceedings. But part of that landowner bill of rights that you will receive, you've been condemned, and you look over here on the side, that's exactly what it is, the state of Texas landowners bill of rights. And if you'll notice on paragraph 8, they actually notify you that yes, you can hire an attorney to negotiate with the condemning authority to represent you. A lot of times, and we'll talk about this process, the right of way agents will tell you, don't worry about hiring an attorney. They're just going to take all your money. You might as well just trust us and do what we tell you to do. And I emphasize this because the state of Texas says you have the right to consult with an attorney. Well, a lot of people want to know, okay, what am I going to get paid? And that is complicated depending on your property, depending on the type of taking, but it has to be for adequate or just compensation. Now, notice I did not say fair compensation. There's nothing fair about this process. When it's a taking and it's not a sale, you don't have any control over it, and that's frustrating for every landowner. I don't care if whatever your profession is, whether you're a developer, whether you're a homeowner, whether you're a small or large property owner, it is frustrating when you don't have the control over this process. And you don't. The condemning authority does under Texas laws, whether it's the Texas Property Code or the Texas Constitution or Texas Supreme Court opinions. And I highlight the taking and the remaining portion of this property because how do you evaluate what their offer is? Are they giving you fair market value for the land that they're taking? If TxDOT is taking part of your property, are they giving you the value of what that property really is worth? If it's a pipeline going through the middle of your property and it's a gas pipeline, is the rest of your property damaged? Do you have a home within 1,000 feet of that new pipeline? So the remaining portion of your property, not just what's being taken, could be damaged. And it's really important to understand when you get that offer for the condemnation process, regardless of the type, is it a fair? Well, it's probably not going to be. Is it adequate or just? It may be, but that's where you really need to start talking with someone such as an attorney who is a expert in this condemnation process. And I put this image up to give you a sense of this is your property. And whether it's a pipeline or transmission line or a new road, the red is what's being taken, and the green is the rest of your property. So, what does the law say that you're entitled to for adequate or fair compensation or just compensation? Because it never will feel fair because you don't have control over this process. And total compensation, according to the Texas Supreme Court, is that they value the property before the taking, and then you value the property afterwards. The difference between those two numbers is adequate or just compensation. And I'm going to give you an example here in a minute about how different those numbers can be. But the remainder is what's left after what's being taken. If it's TxDOT or the county or city or a government is taking this for a new road, they're going to own that part taken. If it's a easement or a pipeline easement, you still own the property. But what's red is also now encumbered by an easement by a third party that has the ability to operate and maintain, construct, and repair a transmission line or a pipeline of any kind on that part taking. So we look at, are they giving you the value of what's being taken? We look at, is there any damages to the rest of the property? And there's also what's called a cost to cure item. That item is, are they going to take, I have a really nice entryway. I have a really nice fence, or they're taking out a water well. What's the value of that? They have to pay you for the damages associated with not just with the part taken or the remaining portion, but also what's it going to cost you to cure the damages, and then they should have to pay for that. Here's a good example of a TxDOT case. It's actually a case I handled in Bexar County, Texas. It was TxDOT. The market value of the land was, I'm going to use rough numbers here, was $2.8 million. Their improvements, which was a business, a hardware, farm store, 1.8. So the total value of the property and the improvements at that moment in time, market value was $4.7 million. Now, the improvements were taken out. So the value of that is zero. We also lost market value of the whole remaining piece of dirt or the rest of the property minus the improvements at a 1.1 million. Now, TxDOT did have some temporary easements for construction purposes, staging purposes, so they offered a little close to $5,000 for that. So our argument was that you have damaged the property $3.6 million. Well, guess what? TxDOT's appraisal was 2.47. So we have a difference, I call it a delta, the difference between our valuation of damages, TxDOT's valuation of damages, and that was $1.2 million. That's a significant difference between the two appraisal methodologies. And you may ask, how can that be? Well, appraisal methodology is an art form. It's not an exact science. Now, most of us can say 2 + 2 is 4, but in the appraisal business, the numbers can be really subjective. And depending on who the condemning authority hires an appraiser, who he hires an appraiser, or there's other experts that we can hire, that's where that difference can come into play. And that's where the expertise of a good condemnation lawyer for landowners can really help you out. I'm going to talk about the 5 stages of condemnation. I'm going to go through each one of these in a little bit more detail, but basically the first one is, what is TxDOT doing? What is the pipeline doing? What is the county doing to, are we going to build this new project? Where are we going to get the money for it? Is there going to be public input? Right now on these 765 kilovolt transmission lines around the state of Texas, various companies such as Encore, LCRA, and there's going to be other transmission line companies. They're going to hold open houses in where they're going to invite you to come into a community room, have a bunch of poster boards, and show you what their plan is and get your public input. TxDOT does this on a regular basis, and they want to know if we're going to build a new roadway or we're going to widen a new roadway. If, for example, you're in the Dallas area, the 360 project has been going on for a while. They've had lots of these type of projects in order to get public input. That's the first stage. When they start using their eminent domain authority to condemn, they're going to contact the landowner. If that's you, they're going to ask you to be able to survey the property and maybe get a right of entry. And then the next three phases are really the heart of the condemnation process. What's the initial offer, final offer, and then are they going to sue you in a petition and condemnation? Let's start with step one. So step one, again, is that project planning and the input. Pipeline companies do this on a regular basis. They're going to announce we have a new pipeline project. Every county and property owner that is in the way of that particular project, they will invite to a community forum, or sometimes it's online, sometimes it's in person. It could be a combination of things, and they're going to ask for the public input and establish that they do have a public purpose for this particular project. Ultimately, is it going to serve the better good? Now, can private entities actually do this? Kinder Morgan is a private pipeline company. Can they do this? Yes. The state of Texas has given them eminent domain authority to condemn private property for a gas utility line project. Atmos is another one. They are routinely improving, upgrading, and building new gas lines around the state of Texas. Believe it or not, a school could condemn if they wanted to for new property to build a new school. So it's a very broad brush of what the condemning authorities have. And what we always look into, do they have the authority to do this? And if so, what's the statutory or constitutional authority? The second stage is that initial contact, where the condemning authority is saying, we're looking at your property. We would like to survey your property. Absolutely, they have the right to do that if they have eminent domain authority to condemn. But what we look at is what is the guidelines, limitations? If it's a private company, do you have insurance? What part of the property do you want to access? Oftentimes, the landowner will receive a very blanket, broad form to say, yes, you have the right to come onto my property. We work out a right of entry form that limits the amount of time, limits the access to what portion of the property is necessary, and also make sure that you're protected as a landowner when third parties are on your property, either to do surveys or appraisers come on to look to devalue what is the offer that they want to give you in the initial offer. This is the point in time where you haven't talked to an attorney. You should consider talking to an expert that understands this process and can advise you. Our clients routinely ask us to do a right of entry to say they only have 3 months or 6 months and only on this portion of the property. That's a very important step in this step two of this process. Now, step three, that's where they've done the survey. They will send you some information to say, here's where we want to put the pipeline or transmission line. Here's how much land we want to take for the new road. And they're going to make you an offer. And it will be a financial offer that says you only have 30 days. Sometimes they say 33 days. And sometimes actually they don't say how many days you have, but by law under the Texas Property Code, they have to give you at least this 30 days to respond. Now, what is the consequence if you don't respond? Well, there is no consequence other than they move to the next stage. But this 30-day notice will give you an offer. It's a time for you to assess the offer. Now, part of what the condemning authority has to do is give you an appraisal. They have to, at some point in time, say, we have hired an appraiser to come up with a damage model that we believe is fair compensation. Now, again, I said fair. They think it's fair. Is it adequate? Is it just? That's where I come in, or my team comes in. looks at that offer and says, it's good, it's bad, it's way low, or you want to take it. We do that for our clients all of the time. Now, rarely do I see an initial offer under this 30-day time period that I believe is adequate or sufficient for my clients. So if you don't accept this offer, and when I say bona fide, Texas law says they have to make a good faith effort. And again, appraisal methodology is very broad, it's very subjective. And so my interpretation may be very different than what their initial offer is. Once the 30 days expires, they have to then give you a 14-day final offer. Now, when I say final offer, that can be very intimidating for landowners because the question is, oh my gosh, it's a final offer. I must act and either accept it or reject it. If you don't accept it and you reject it, then it goes to the next stage, which we'll talk about. But if you don't do anything, it still goes to the next stage, the fifth stage that we'll be talking about. Now, if this is the time to be negotiating definitely easement terms or negotiating final compensation or telling them it's not enough money or why are you so close to my home or are you taking a barn? Because if it's an easement, they cannot take it and then not give the opportunity to use the property. But the problem is your use of the property is very limited. You can't build on the property. I have a client right now on a new pipeline is taking out their barn that they use for horses, and they actually have stalls that people rent for their horses. It's going to take out that barn. They're going to have to relocate that barn. That's a cost to cure item, if you remember me talking about that before. Because if it's an easement, you can't build a structure on it. If they're taking in a fee, if TxDOT is going to own the property, well, you don't own the property anymore after that. So after the 14 days expires and you still haven't negotiated, but you really should have talked to an attorney at this point in time, unless you're just very comfortable with the offer, you sign whatever. The land agent is going to be talking to you repeatedly, asking you to go ahead and settle before it goes to their lawyers. If you don't sell at that point in time, then stage five. Here's where it starts getting a little bit more stressful and complicated because a petition in is filed. You're sued. So the landowner receives a lawsuit. It could be by a process server, it could be by registered mail, but the reality of it is that you are now in a lawsuit in a district court or a county court of law in the county in which the land is or in a district where the land is, and then the clock then is starts differently. So we've gone through the procedural aspects of the 30-day offer, the 14-day final offer. Those are required by the Texas Property Code. Now, the problem that the condemning authority has is they don't have possession of the property. Other than the survey, they don't have a right to be on the property. They don't have the right to condemn the property at this point in the sense of having possession. Now, the condemnation process continues. A lot of times people ask me, well, I'm not in condemnation. As soon as the request for survey happened, you're in condemnation. A lot of people like to equate, and condemning authorities do this all the time, that we don't want to condemn you. What they mean is we don't have to file a lawsuit against you. We don't actually want to file a petition or a lawsuit. That's what they think condemnation is. But the condemnation process already started when they asked to get on your property and actually survey the property. So what happens next? There's two phases. There's the administrative phase, and then there's trial phase. So what happens after the lawsuit is filed is that the judge appoints three residents. And when I say residents, they have to own land in the county where your property is. They also have to be a resident. They can't just own the property and live in Europe and be a commissioner. So they have to be a resident, unbiased landowner in the county. Three of those are appointed by the judge. Now, they're not county commissioners, they're not the county judge. They're called special commissioners under law. And what is their job? Their job is to decide compensation. And when I say compensation, that's a number. If the condemning authority is at 2 million and we're at 3 million, they decide a number between the 2 and 3 million, put that in the registry of the court. Why is this process? Why does it exist? Well, it exists because the condemning authority needs to have what's called possession. The only way they get possession is if they've already settled with you during the first, phases that we've talked about or steps that we've talked about. If you settled with them, then they have possession. They can start construction. If you haven't settled with them, then the only way they get possession to actually start construction is to go to a special commissioner's hearing unless you give them authority otherwise, and that's not part of this presentation. But if they go to the special commissioner's hearing and the commissioners award a number, that number is deposited in the registry of the court, and then they can go ahead and start construction. Even though you haven't settled with them, they can go ahead and start the process of bidding out the project and getting contractors on the land so they can be on the land at this point in time once they deposit the money that the special commissioners have requested or have given authority, and that money is deposited in the registry of the court. You could take that money out. Also, that is a very important thing to be discussing with an attorney as to whether you should if you haven't settled with the condemning authority. Now, whatever they decide, if they decide whatever number, whether it's $10 or $100 or $1 million, that is not the final decision. That is only to give the condemning authority the right to go ahead and start possession of the property. If you don't like that number, if the condemning authority thinks it's too high, if you think it's too low, either side can basically object to that award, and then you're at the trial level. What happens next is that the judge will set it for trial. And if you go to a jury trial, it's the jury's decision in order to decide what compensation is. It doesn't matter what the special commissioners decided because the jury will never hear that number. But here's one of the problems when you go to a jury trial. If you have experts or hired an attorney, if they're on an hourly basis, it gets expensive to go to a jury trial. So the economy of a business decision has to be looked at this point in time because you don't want to be spending more money in order to get less as far as the taking is concerned. And yes, that is very unfair because you don't get your attorney's fees back. Even if you win, you can't claim your attorney's fees. You can't claim to be reimbursed for what it cost you for the appraiser or other experts. You can't get that money back. So if they've offered you $50,000 and you spend $10,000 and the jury gives you $30,000 or even $60,000, you may be spending more money to get less money. That is really complicated. And if you decide to go that direction, you really should be talking to an attorney about the risk involved and what it's going to cost going through these various processes at the very early stages. And I really encourage people to at least start inquiring at the survey stage, that very first stage in the condemnation process. Certainly by the time you get the 30-day offer, because that 14-day final offer is going to come, you're going to feel stressed about what should I do. You don't want to make a bad decision. You want to make a good decision, but you also don't want to be in protracted litigation. And I have clients who have been in that litigation for, 2 or 3 years, and we're just now resolving the cases because we were so far apart on the various numbers between the initial offer, the final offer, whatever offer they made. And then a judge is going to require what's called mediation to try to settle that process. So it can be a long, drawn out process, and you have to decide if it's worth it for your particular situation, your particular family, your particular lifestyle, your particular property. What is the taking? And it's very lots of decisions to be made, and you want to make those in a very educated way. So, why are we really concerned right now in the state of Texas about what's happening? Because, oh goodness, I don't know where you live necessarily or what you've seen. I've lived in the Dripping Springs, Texas area for 25 years. We moved out here from San Antonio, although I've lived in most of the state of Texas, from the Texas Panhandle to the Rio Grande Valley to West Texas, and I have seen tremendous amount of growth in my area. And I think wherever you live in the state of Texas, there's a tremendous amount of growth because of the population growth. What does this require? Well, it requires more roads. It requires more infrastructure. It requires more energy with the transmission lines that have been built or going to be built, with the gas and petroleum products that Texas is known for. That has to be expanded. Local county and city road projects are on the rise because there's so much population growth. And part of the problem is, where does that money come from? And that gets complicated as well. It could be from bonds. Local governments often have bonds that are on the election. And if that passes, say it's a $4 million or $400 million bond, a lot of that money is going to be used for increased infrastructure. Now, sometimes the federal government provides state funds to, or the funds to the state or to local governments. But right now, TxDOT is very limited on its funding until September. So a lot of projects are on hold, for example. So one of the big question is, where do these condemning authorities get their money in order to build this new infrastructure? With the energy development that's happening, the liquid natural gas exportation that's happening, most of the gas is coming from the Permian Basin, going to the Houston area. It's being compressed and it's been shipped overseas. And yes, private companies have the authority to do that in the state of Texas and actually sell it overseas. That is still for a public use according to the state of Texas. So it's always a good question to ask, can they do this? Can they take my land for this particular project? Is it really for a public use? And in general, roads and transmission lines, yes, are. Sometimes pipelines aren't. Sometimes private pipeline companies come in and they don't have eminent domain authority, but they still negotiate. It's really important to know, does that company have eminent domain authority to condemn, to take my land for public use? So that's the first question. Can they do it? Most of the time, 95, 99% of the time, they do. It's a rare occasion that these days that they don't have the authority to go ahead and condemn. This is a little recap. Want to just really, it's a lot of information, I understand. And I just want every landowner needs to know what their rights are, what the process is. And again, is there a legal basis for what the condemning authority is trying to do? Can they take my land? If they can't, then you can just say no. If they can and you say no, well, they can use their eminent domain authority to condemn. So, public use again historically has been for roads and even for park systems and school systems, as I mentioned. But I have a lot of people ask me, like on the gas pipelines, if all that gas is being shipped overseas, how is that for a public purpose in the state of Texas? Well, we have actually litigated that in the federal courts, and the federal courts have said as long as the infrastructure is within the state of Texas, then yes, they can do this. Now, there is a federal process by which pipeline companies who go from Louisiana to Texas, for example, can go through a federal process and get authority from the federal government to go ahead and condemn. If they don't do that, then they may not have the right to condemn. And so that's something we can look at and decide. For most people, it is, oh my gosh, are they paying me an adequate or just amount of compensation for what they're taking? they're required to go through this process. They're required to make you the initial offer and give you 30 days. They're required to give you a final offer and give you 14 days. They're required to file a petition in condemnation if you haven't settled the case. But if you're not an expert in this area, if you're not an expert in real estate values, if you're not an expert in what is this going to do to my property, I have a lot of clients who are really concerned about the restoration of their properties. You know, my land, if it's going to be built for a pipeline and they're going to bury it 3 to 4 feet, and I am going to lose my surface of natural soil and topsoil. I'm going to lose all these beautiful wildfires or whatever grasses that you may have. It's going to be close to my home. What are the impacts? And how can I ensure that if this is going to happen and I can't stop it, and you can't stop it as a general rule, then you're just going to have to decide if it's going to be a taking and they're going to have to go through this process, at least make sure that I'm getting, the amount of money and that is just and adequate as I can get. And if it's an easement, easement terms can be very, very critical. And that's something we negotiate all the time with the condemning authorities. Because if it's a pipeline, you may ask, well, what happens if there's an injury? Am I going to be liable? Is a property owner liable? Do they have insurance to cover this? Do they have to give me notice if they're going to be on the property? Because if it's an easement, you have a third party now that has right to access your property at any point in time. And that is not comforting to know that now you're in the middle of wherever and you have your privacy, but now you've got a third party that has rights to access your property. And you're going to want to be notified if they're going to be there. Now, if it's an emergency, that may be a different situation. But there's a lot of stress involved in this process that I've experienced over the decades that I've been doing this. Is it's consistent that people are anxious and they're stressed about it. When it comes to pipelines, I have clients now who are getting their second, third, fourth, fifth, sixth, and even seventh pipeline across their property. If you're getting a fifth pipeline, how do you value the damages on that? And it's complicated, and the law is changing, and we can at least help give you some comfort to know that you have somebody on your team that only represents landowners. So this process I've gone through, and we'll do this again here, and whatever Francesca tells me that we want to do it again. So you'll be notified if you want to attend again and you have more questions. And again, I'm going to finish up here in about 5 minutes so that we have questions that can be asked, and I can give you those answers through Francesca. But you do have rights, and a lot of people ask, well, can I stop it? No, not if the condemning authority has the authority to do it and it's for a public use. So it's a matter of what are your rights and how do you manage to get the best compensation or the best terms of the easement. Sometimes if it's a text dot issue in the morning, I have a call with the authorities to talk about access because we're really concerned about the expansion of the road on this commercial piece of property and how we're going to access our facilities. So we're going to start those negotiations early to figure out if we can have a different design that is less damaging. So part of what I like to do and my team does is to look at it and say, can we minimize the impact? Can we make it less harmful rather than more harmful? And that's part of what we do as far as our representation. Our role, and if you notice these 7 items, or is it, 7 items or italicized, helping, negotiating, relieving, choosing, balancing, getting, referring. So we really want to help our clients advocate through this process to damage the property the least, negotiate the important documents like easements and compensation. Part of my job, seriously, is to relieve the stress of navigating through this process to know that somebody has your interest and your back And I have the experts, relationships with the experts, whether it's an appraiser or it's an engineer or it's a land use. It depends all on the property and depends on whether or not it's worth hiring experts in order to help because they do have to be paid. Balancing the decision between do I accept the offer now? Do I delay it? Do I go to a special commissioner's hearing? Do I want to go to a jury trial? How do I make that decision? And it's a balancing between, time, economics, cost, return, stress on your life, and everything else. So it is a balancing of trying to make the best decision. And we do focus on getting you the best deal that we can get for our clients. And then there's another issue related to if I get this money, if it's not a sale, if it's not a purchase, what is it? Well, the IRS, Internal Revenue Code, has a special provision under 1033 that these exchanges have special tax consequences for landowners. So we can refer you to tax specialists. I'm not a tax attorney, I'm not a CPA, but I've been doing this a long time and I can give you some good recommendations on what are the tax consequences for these funds when you get those funds. I appreciate your time. Again, I'm Patrick Reznik. I've been doing this for a long time. I only represent landowners and happy to visit with you at no charge for a 30-minute consultation. A lot of times my clients ask, well, how do you get paid? I get paid either by the hour or mostly 95% of my work is through a contingency fee agreement. So I get a percentage of what I do to improve the compensation. For example, if they offer you $1,000 and I get you $3,000, that I get paid a portion of the $2,000 difference. And that is something that if you decide to hire me, that we can negotiate what that term is and who pays for experts and that kind of thing. So happy to visit with you. Again, we provide a 30-minute consultation at no charge and no obligation. We just want to make sure landowners around the state of Texas are educated, treated fairly, know what their rights are, and know the process, and then decide whether or not we can add that value added service. And I believe that we do. And I'm going to turn it over to Francesca now to talk about the Texas Land Advocate, what that newsletter is. It's been something we've been doing for at least 15 years. It is a newsletter that we find is very helpful to our clients, to people who are not our clients, just to the general public. But you have to sign up, and I'll let Francesca talk about that and close this evening. See if there's any questions. I really appreciate and respect your time today. Thank you so much. If you want to reach out to me with this email or call and ask for a consultation, please jot this down. Please write the number down and I'd love to visit with you. And Francesca, thank you so much for the introduction. I'll leave it to you to close up.
Thank you, Patrick. And I'm going to go ahead and ask you some of the audience's questions before we talk about our newsletter. So, one question that our group had today was, can an energy company be forced to bury transmission lines that would minimize the impact, and should they bear the cost?
The answer is no, they cannot be forced to bury transmission lines. And remember, a transmission line is just that. It's a distribution system. Let me rephrase that. It is not a distribution system. It's not like getting energy to your home. Subdivisions often bury distribution lines, so you don't have any overhead poles. Transmission lines are not buried. Now, there are a few locations around the state that are buried. The utility companies can't be forced to bury it unless it's a federal government piece of property and they allow that transmission line, like near an Air Force base, and they can require it to be buried, but that is rare. And one of the reasons is that the expense of burying a transmission line is very expensive. It can be up to estimates are up to 10 times the cost of overhead. The Public Utility Commission of the state of Texas regulates these transmission lines, and they will never force the burying of a transmission line. I wish it was different, but we have worked out a few deals where, for example, a city going through a portion of town paid for the burying, and the Public Utility Commission authorized that. But that is a rare event, and the answer no, they cannot be forced. So thank you, Francesca.
Thank you, Patrick. And then another question from our audience, is there a typical percentage between, or percentage difference, excuse me, between an offer and what is reasonable? Another way of mentioning, is there a typical discount on the valuation for the first offer?
There is not, and the reason being is because it all depends on the property, where it's located, how big it is, what's the use is. Is it recreational? Is it a farm? Is it a ranch? Is it commercial? Is it residential? I can, as a general rule, I would say there is a factor that could be 1.5 times more and even up to 6 or 7 times more than their initial offer. But that's why it's important to get this advice so I can look at the property, look at the project, look at what the damage is going to be, and give the landowner a sense of whether it's a good offer, a bad offer, and whether it, if we're going to end up with 8 more times than the initial offer, then that's a big difference than 1.5 times the initial offer. So I can't generalize that, unfortunately, because there's so many different unique circumstances. And I do tell my clients if the offer is good, don't spend money. Go ahead and take the offer. And maybe I can help you negotiate a better easement terms or something of that nature. But I can give you a good sense of their offer and whether it's a good offer or a bad offer or an extraordinarily awful offer. For example, recently just negotiated a deal where the initial offer was $60,000 and we ended up getting the client several $100,000. It just depends on the situation and the land and the project.
Thank you, Patrick. Can the condemning authority demand use of the landowner's existing roads that are not within the proposed right of way to be condemned?
The 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 answer is yes. What I like to see, if they're going to use roads that are on the property to access, let's say, a pipeline easement of some kind, then I like to see them pay my client for either a temporary access road or a permanent access road. They don't automatically have the right to use that road, even though it exists to access their project. They should have to pay the landowner for that, and it should be under either a temporary access or a permanent access as part of the condemnation project that they have. I recently dealt with this as of the last couple of weeks on a LCRA project where their petition and condemnation said we have the right to access all the roads. I'm like, no, no, not without an easement, not without something, a temporary easement or permanent access easement. And we just negotiated that as part of the overall settlement. So they may try, but I think it's inappropriate at a minimum. And you should be able to pay and have some sort of lawful document that gives you the rights under a temporary or permanent easement for that access.
Thank you. On transmission lines, can the placement of a transmission tower or line be negotiated if you have a large piece of property?
The answer is maybe. We like to say, well, it just depends. But it is something that absolutely can be discussed and negotiated, especially if you have a larger piece of property where they have more room. The problem in the condemnation process is that if they relocate the line on your property, is that going to impact neighboring properties? If it's going to impact neighboring properties and they're going to have to relocate a structure or the line, then you're going to have to work to get permission from those adjoining or contiguous landowners in order to do that. And that can be complicated. But if you have a large enough piece of property And we often will try to negotiate to move it away from the home, for example, or move it back behind the entrance if that's what the client wants, or to avoid taking out a water well or something in that nature. So it can be negotiated during the condemnation process. It's certainly worth a discussion. Can you force it to the condemning authority to relocate? You can't force it, but it's something that we often discuss and are successful in negotiating if it has some feasibility from an engineering and land use standpoint.
Perfect, thank you. Is it true that if you settle under the umbrella of condemnation that the proceeds are not reportable to the IRS via 1099?
So, again, I'm not a tax attorney or a CPA, but as a general rule, the money that you receive in a condemnation proceeding is not income from a sales standpoint. So it's not a sale. A lot of CPAs don't understand that when my clients get that money, they look at it as regular income from a sale. That is not the case. You really want to talk with your CPA about what is the tax treatment of this? And depending on the project, it has different tax consequences, but there's definitely some benefits under the IRS 1033 provision that I mentioned. Also, there's land damages issues that can be treated differently by your CPA than certainly a sale. So absolutely, I have that discussion with my clients. If your CPA says you don't have to pay taxes on it, then I trust the CPA. But again, it depends oftentimes if it's a taking where they're going to own the property versus if it's going to be an easement. So there's various tax consequent differences depending on the type of taking that it is.
Thank you. What is the method to determine damages for a pipeline? So this is a high pressure natural gas line that's within 350 feet of their home.
The What I do with my appraisers as a general rule is that if there's improvements on the property, we include the improvements as part of the total valuation of the property. So we look at the land value and the improvement value. A lot of times, the condemning authority does not take into consideration the improvements on the property. So we may be in agreement that the land is worth, for example, $10,000 an acre. But we've added $500,000 for the improvements, and we believe the improvements are being damaged because of a high pressure gas line on the property, and the condemning authority doesn't. So even if we agree on the valuation of the land, we believe that depending on the location of the improvements or the home, for example, close to the pipeline, the closer it is to the pipeline, we believe the more it damages because what we look at is that from a common sense standpoint, if you were to put the property on the market without a high pressure gas line and with a high pressure gas line, as a general rule, the one with the gas line is going to sell for a percentage less. It may be 5%, 10%, 15, 20. I've seen some projects that it's up to 40%. And that's where the expertise and the data that our appraisers have really comes into play because they have to have good sales data to show that properties with this new infrastructure is going to sell for less money than properties without that infrastructure. A lot of times that is the difference between what the condemning authorities appraisers think the damages are and what we at our appraisers think the damages are.
And one more question, Patrick. So a property is potentially going to be impacted by a text dot widening project. When should they consider consulting with Braun and Gresham?
On a TechStop project, in any project, once you receive that information for the survey, I would say at least let's have an initial conversation about it. I have clients right now that have been on various TechStop projects for a year, 2 years. I have a client that has been 3 years since the project was announced. And often they call me just to say, hey, what is the status of this project? I find that very, very valuable, and we provide that as a service. If I'm on a contingency fee, I don't charge my clients, of course, for that. And I had a call this last week on a particular project to say, hey, this has been going on for a long time. What's the status? And I can tell them, you know what, the design is now 80% designed, 90% designed. We expect that they're going to have funding in September, so we expect surveys to start right after the first of the year. So one of the big questions that landowners have on, especially road projects, is timing. When is it going to happen? And it all depends on when the money for the project is going to be advanced. And we stay on top of that. We just had a county bond that was challenged in court that was declared inappropriate because of the open records and open meetings violations. And so that bond, that even though it was passed by the landowners or the community and the voters in the community, it has now been put on hold because the money is not going to be available because legal reasons. And so I've been telling clients it may not happen now for another couple of years. It depends on how the county decides. And so when it comes to those type of projects, timing is really uncertain. With pipelines, they're usually imminent. With transmission lines, they're going to happen within a certain period of time. So we often know the timing on pipelines and transmission lines. Road projects often can be really delayed, and then all of a sudden it's hurry up and get these projects built because now we have the funds. So I would say the sooner the better on any particular project. And so you have the updated information. So if you are in the condemnation process, eventually you have somebody that you can consult with without having to scramble at the last minute to find some help.
Thank you, Patrick. All right, everyone. So that is the last of the amount of time that we have for questions. But if we didn't get to your question today, it's just a reminder, we're going to be following up with an email and introducing you to our team so that if you do have any questions, you can contact Patrick or Carly or anyone on our condemnation practice team. I'm going to talk real quick about our newsletter before I leave you today. So our monthly newsletter is called the Texas Land Advocate. To subscribe, you can scan this code with your phone, or you can visit our website. You can fill out the contact form, or in the footer, you can simply drop your email in, and then we will send you monthly information. So through this series, we share important landowner alerts, firm updates, upcoming events, educational tips to help you navigate land ownership with confidence. Thank you so much for joining us today. We hope that this presentation has equipped you with the knowledge that you need to navigate the complexities of condemnation and eminent domain with confidence. Thank you. And thank you, Patrick, for all of your informative information. This has been very valuable.
Thank you, everyone. Thank you, Francesca. Everybody have a good rest of your week and happy 4th of July.
Thank you.